Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Typical, she says to herself. I hope everybody's doing well. I am not in my kitchen because I forgot that today is actually a national holiday in Canada, which means that my kitchen is not empty, my house is not empty, and so I am relegated to my studio to be loud and have the show. But that doesn't mean that we're not going to do it, so we are going to watch some court. I got some great ones this morning. Thank you, Courtney, by the way, for the tip-off. I hope everybody's having a wonderful Monday. I mean, I'm just, not going to cook. I didn't call it cooking and court. We'll round out the last day of what has been a good and bad month. Yay, so good. Thanks to people like Miss Casey Carey. But in fact, a pretty down month. I am glad that it's over, I would say, and we'll start again in October and see how we do. You called it cooking in court all over Discord. Well, I don't care. It's a holiday. Do you want to know what the holiday is today in Canada? It's called National Truth and Reconciliation Day, and it's in regards to the atrocities that the Canadian government committed against the First Nations people in our country. And it became a holiday maybe 2 or 3 years ago. We're not cooking anything, Mikey. Nobody said we were. We're talking about, in fact, a very serious subject. Truth and reconciliation. It's very sad. But you're back today, right? That's exciting. Exciting, exciting, exciting. Oh yeah, the storm's over. Everybody survived the storm. You were not promised cooking. You were promised nothing. Hi, Trish. How are you? Ah! Yay! Our boys are back in town. How exciting. And Trish, thanks for being back. We're glad to see you. I didn't promise anybody cooking, and like I said, there's people in the house right now, so I can't go in there and take it over and run a live show as much as you guys would like. There's like multiple reasons why I can't do that. So, but we can watch court that I worked on getting this morning. Sort of like cooking. Cooking up some court. How's that? Let's start with a snippet in Thurston that's just a... Oh, and by the way, that means I'm taking tonight off because it's a holiday. May as well. Oh, hello, green screen. I'll have to fix that. Oh, Trish. Oh, you're so sorry. I'm so sorry. Oh, I'm sorry to hear that. But we're glad that you're here, and this lady here that we're going to hear from, when it might make you laugh. Sorry, I have to fix this green screen. There we go. Okay. Okay. Let's play. If you can't tell, I have not had a sip of coffee today, and I woke up, I don't know, on somebody else's bed. Not really, just like the wrong side of the bed, you know that saying. I woke up in a different time zone. But Trish, I'm glad you're here. You're gonna laugh at this lady, I promise you. Let's start with this.
And then is Jennifer Vitovich here? Is not. So Ms. Bondurant, are you still on the Zoom call there? And if you're on the telephone, ma'am, there,
Yeah, I'm
Samsung,
here.
are you? And it says Samsung SM F741U. You're Ms. Bondurant?
Yes.
Okay. So again, Jennifer Vitovich does not appear to be here. It's now 9:40. Given her lack of appearance, ma'am, this will be dismissed. She may, I don't know what happens. Sometimes people want to refile these when this happens.
Can you just do a
And,
motion to waive?
Motion to waive what?
I don't know. I heard that once on TV.
Okay, well, so she's asking for.
Did you hear that? She just repeated something she's heard on television in real court and admitted it. And she was also winning. They're dismissing the case. And she's asking for a motion to waive, which doesn't even make sense. Even to us court freaks, that doesn't even make any sense. I was laughing so hard when I heard this. I was like, did she just say that? And the judge, watch him. It takes a minute because he like answers first and then giggles. It's so funny.
So again, Jennifer Vitovich does not appear to be here. It's now 9:40. Given her lack of appearance, ma'am, this will be dismissed. She may, I don't know what happens. Sometimes people want to refile these when this happens.
Can you just do a
And,
motion to waive?
Motion to waive what?
I don't know. I heard that once on TV.
Okay, well, so she's asking for an order against you, right? She's a petitioner. She wanted an order to keep you away from her. So since she didn't appear, then this gets dismissed. There's not an
Oh,
order.
okay, cool.
So I said, she can refile if, sometimes things happen, like their car broke down or couldn't get connected or we live in an era of Zoom, which is everyone can tell, doesn't always go smoothly. It's not going smoothly all that here this morning. Sometimes people, can't get in or they're not available, whatever. So they'll still want the order. So they'll refile it. So she can do that. But since she didn't appear, it's going to get dismissed here for today.
Okay. Thank you.
Welcome. We can do that one later. And so, yeah.
Well, it was
Later.
dismissed
And you're free to
before she
leave the
said
Zoom call.
anything.
Okay, thank you.
Sure.
And that was that clip. A beaut, right? Then we head over to Kansas quickly, where this woman, is it ready? Yes, it's ready. Good. It's ready. Hi, Bradley. The boys will be back this afternoon with We Gotta Chase, I'm sure, with a bang, Bradley, but we're glad to have you. We are now zooming our way to Kansas. 1 minute. Jay Regier, you'll see why.
That's
in
a
a
coach,
moment.
right?
Yes.
Yes.
And I'm wondering if she is still in an earlier break. Well, no, she left that breakout room, I thought.
Anybody
But I'm
know
not-
where Miss Huerta went?
Paul actually had her in the waiting room because she was being disruptive with the chat.
Getting disruptive with what?
On the chat,
Oh, yeah, sending out chats. Okay, let's see if we can get her back. There she is. All right.
So I didn't want to make you guys wait any longer. I have this has been like a 3-hour hearing, and 2 hours ago or something, there was a Spanish interpreter, and she started typing Spanish to the interpreter in the chat, and the clerk thought that she was requesting a Spanish interpreter, and so she like stopped the proceedings and was like, Your Honor, before you let the interpreter go, I think she needs an interpreter. And the judge was like, oh, the lady in the stocking hat. And I was like, what? But I guess that she thinks it's a stocking hat. But the girl then got on the phone. But the judge was like, you can understand me. You understand because she was like touching her hat when the judge said hat. And like, you could tell she was hearing what the judge was saying and understanding it. I got that clip. It's just on my other computer. I didn't want to waste time grabbing it onto here. But anyways, then hours go by and she disappeared. But evidently she didn't need an interpreter. But hours go by and finally this was her hearing. And, well, it gets even weirder.
Now, Miss Huerta, you can start your audio so we can hear you. Click on the little red thing that looks like a microphone with a line through it.
Okay. Hi.
On the record in 2022, CR 458, State of Kansas versus Kristen Nicole Huerta. Please announce appearances.
Jared Regier on behalf of the state, Your Honor.
Joshua Andrews on behalf of Ms. Huerta, who is also present.
And how does she wish to proceed?
Your Honor, if I understood correctly during my brief breakout room with Ms. Huerta, she is wanting to pursue the possibility of additional discovery. So I believe she is asking me to request a continuance of the jury trial setting.
Well, what kind of discovery is she not, that she doesn't have that she thinks she needs?
She had indicated that there may be some phone records that would be beneficial to her case, Your Honor.
What kind of phone records?
Cell phone records for the alleged victim and another witness.
Do you have any such records, Mr. Regier, or can you get them easily available or readily available?
Your Honor,
Your Honor, I don't believe these would be records in my understanding is from, if I understood correctly, these are not records that are in the state's possession, but instead she believes that the phone company would be able to provide these records.
Well, let's make sure, Miss Huerta, I don't want her, if she's got a legitimate defense, I want her to have it. But if she's just going off on a tangent, I don't want that. The burden is on the proof of the burden or proof is on the defense of the state. The state has to prove that she either harassed someone by a telephone device or she didn't. So I would think that that would have to be records the state would produce. I failed to see what it is that would justify delaying this. This allegedly happened, as counsel knows, September 19th, 2022, 2 years ago, and then we'll have to move it into February. In all candor, Mr. Andrews, you believe these are records that could help your defense, or they're just records she wants?
I cannot answer that based on the brief conversation I had with Ms. Huerta. My understanding is she believes that it would show it would put the conversation that is the text messages that were provided by the state in a better context, but I've not had the opportunity to discuss with her what these are in those records that would put that in that context, so I can't answer as to whether these records would turn out to be helpful to the defense or not.
Well, she's charged with telephone harassment. And just in the time she's been here, she's had to be put in the waiting room because she was so busy sending everything to us. Here's one that as Mr. Andrews, have you seen these?
I've seen many of them, Your Honor.
Like
We-
here's
we-
one. What's this one about 3/21/1957 question mark? Marcella 75 something around 199X.
Your Honor, I don't know. Ms. Huerta has had a competency evaluation already. It was determined that she was competent to stand trial.
Right.
Okay, that clears things up a little bit. She's had a competency assessment already. They've determined that she is competent. The question to the chat right now is, where did she go? Where did she go? I'd love you to get your guesses in the chat. In the meantime, we're going to talk quickly about this lipstick. It's from the dollar store, because I'm a cheap bitch. It doesn't have a shade. Well, it does. It has a shade. It's number 8. And the line is called Cosmic Colors with a K. Cosmic Colors. Anyways, yes, this is the dollar store item. All my makeup is from the dollar store. Except for my eyeliner, which my sister bought me from Sephora for Christmas last year. Anyways. Where did she go? Where do we think she went, ladies and gentlemen? Where did she go? I think the only thing I'll say about eyeliner is that when I'm putting it inside my line, like eye line, it's probably good to have good quality stuff. I worry about the dollar store, like in my eye. But, you know, not in my mouth. Not on my skin, all that stuff. Anyways, okay, so where do we think she went to smoke some crack? Vicky says to the bathroom. Dr. Green Thumb says gone to get her testicles out of the fridge. She does look like that person. She went to grab her dildo. John. Okay. Courtney says cooking food. She went to apply more super pale makeup. I love it, Paul. All right, let's see.
Right.
Believe that there were indications that she does have some mental health issues. She is under guardianship.
State's position. Where did she go, Miss?
I have to use, can I take a quick bathroom break? I'm sorry, I'm pregnant. I didn't expect you guys to be back on here, so suddenly my
I
case.
can't, hold up. I can't hear you. Get back on screen.
Sorry, I didn't expect to be back so suddenly. My caseworker was sitting in my chair to guard the computer for me. I need to go to the restroom if I might, because I'm pregnant and I didn't expect you guys to intervene or you know. You
Well,
guys
I
have
need to get Mr. Andrews back to work. It's almost
Oh,
lunch.
yeah, okay, yeah, okay.
But, okay, so you've got a case manager with you.
Michelle Crenshaw is my caseworker.
What?
My caseworker,
Your caseworker's here, and you're pregnant. How far along are you?
I'm 26 weeks, I believe.
And are you married to the father?
Are we married?
Right?
No, we're not married currently.
And you don't intend to be?
I don't know what he feels about the situation. I mean, we've been best friends since preschool, so.
Okay, what?
Oh my God. First of all, that is the most honest comment she said. The judge says, are you guys going to get married? Well, I don't know how he feels about it. None of us do, girl. None of us do. None of us know how the men feel.
his name?
I'd rather just not like divulge that information.
All right. Mr. Regier, what's the state's position on this request for continuance of this case that is so old?
Well, Your Honor, in all candor, the state does have some concerns with saying this over yet again. I am showing that previously back in February, subpoenas were issued and witnesses were served for a jury trial setting back on February 7th. Here we are again, and if you'll pardon the conjecture, essentially the same position as we were. As well, and I am showing that for the jury trial setting this week, subpoenas have been issued in that hearing as well. So if the court is inclined to set this matter over, the state would request that its objections be noted on the record, and the state is respectfully insisting that the court make a finding as to whether or not such a continuance is to be assessed against the defense in this matter. Beyond that, the state is prepared to proceed to trial.
Mr. Regier, Mr. Andrews, I'm going to do this one like I've done a couple others. I'm going to put you in the stack of no continuance until I figure out, you'll be the fourth, but I'm going to reevaluate after this docket is over and decide which of you will go and which of you will continue.
Yes, Your
So
Honor.
at this point, continuance denied, and then I will let you know based on my evaluation of which one is priority at that time. So
Very
Ms.
good, Your Honor.
Huerta, you need to be ready to go to trial, and then I will let your counsel know which one of you are going to be the final prime case.
Okay, sure.
Because you could have gotten those records, you could have gotten those back.
Well, I requested them at the beginning of this entire thing, so I don't understand where there was a lag in communication. I don't know if the message didn't get passed from the front desk back to him, or
I don't know
exactly
either,
the
but
communication delay was, but
who is she reportedly harassed, or who did she harass? Whose name is the victim?
Her father, Your Honor.
Her father. All right. All right, I'm going to continue the bond you're on with all existing conditions, and I will let your attorney know if you need to be ready for trial Wednesday or not.
okay, yes, ma'am. Yes, Your Honor.
You may go.
There we go, there we go, there we go. Away from Kansas we fly. But will we see her again? Will she bring the phone records to the case? I don't know. Let's go to Bronlick's court. That we've got 3 cases from there. Ladies, how's the day? How is Judge B today? Is he feeling good? It's a Monday. I just want to know. Oh, sir, you need to reinforce your bookshelves. They look saggy. Balls in bookshelves. You don't want them saggy, guys. No cookies on Mondays on national holidays in Canada, Flesha, but thanks for being here. It's a national holiday, so everybody in my house is here, in fact, sleeping. And so if I go out and put on a live show in the kitchen, which is an open kitchen, frankly, the odds of a naked man coming into the kitchen just to spite me and bother me is high. It's high. And I'm just not willing to take the risk. So I will be cooking up some court. We'll cook tomorrow. They all leave again tomorrow. And tomorrow we're cooking. We're going right back to it. We're going to do some healthier meals this week. That's what I said today. We'll see.
Good morning.
Good morning.
Hey, everybody. Hey, Amber, do you want to do a breakout room or are we good to go? I just got your judgment and it looks good.
I think we're good to go. I have put his address in and the judge's name, and I started to do the child support form and realized I was using the spousal support one. So I'm going to have to send that to you later, but yeah, I think we're good.
That's fine. And then as far as the child support goes, you had sent me a guideline back on August 12th. That's the one I was looking at.
210, I think.
Yeah, 114 for one, 210 for two.
Yep.
Okay. Yeah, I think we're good to go then.
Okay.
Judge will be right out.
Thank you.
Perfect. I will say
Thanks,
about
Jerry.
the cookies. Hey, shut up.
You're welcome there, Newman. I was gonna call you Norman. It's Newman.
Norman,
I know.
I need to get up there if you've
Norman
forgotten me.
Newman.
Yeah, you've got so many names. Newman's my favorite though.
Is this flirting? Is that what that was? Is that the clerk flirting? This is her kind of guy? Really shiny head? All right, girl, whatever. Okay. A relaxed bit of a vibe this morning. That was flirting. That was flirting. She never talks. She never, like, this is back and forth that we don't often hear. Oh, and to think I was going to ignore this one. I'm not kink shaming. Just because you point it out doesn't mean I'm shaming it. We're the most welcoming chat on YouTube, I would argue. Weird kinks and all. You know what I was learning about the other day is that... Never mind, Paisley, don't. It's still early in the morning. Fine, there's a tribe in Zimbabwe where the people have just 2 toes. Like bird toes. And, I just know that's somebody's kink.
Be Norman from Cheers.
Norm, yeah.
There we go.
John,
Not matter,
that's
Daniel
true.
Holman versus Robert Holman.
Only insofar as you add for free to the end. Oh, amputee porn. Oh, that's so last year.
For the record, this matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. Present is Attorney Amber Billmeyer, representing the plaintiff, Danielle Holman. And Ms. Holman appears to be present with Ms. Billmeyer. In addition, Attorney Anthony Brusco is present with the defendant, Robert Holman. Good morning, everyone.
Morning. Good morning, Your Honor.
It's the court's understanding that the parties have reached an agreement that they wish to place on the record this morning. Is that correct, Ms. Billmeyer?
It looks like they may be frozen, Judge.
Yes.
A creed frame on a
We
Monday
were just
morning.
communicating right before you took the bench, so I know it was working.
Not on my end. Fucking finally. Will Creed have one today? Does anybody want to get in on a bet on that? On over under Creed frame amount, or we got a chase later? Legally, I'm not running a booking service, just so everybody's clear. Also, I have to look at something. I think the video from yesterday got fucking demonetized.
Andrea, this is up for tomorrow. I'm just looking at it. This is de novo. It's adjourned, so the defendant can retain an attorney. And the docket says it's Petrangelo, but there's no appearance from Petrangelo nor a response to pleading. So if you can find those. Thank you.
I knew I should have put a sticky note on it. I think this one that Nancy said, Petrangelo, yes, Petrangelo's on this
Okay.
case, and he, the files are already up here.
Okay, if you can find, just see his appearance and the response. So.
Yeah, so, but he's on the case, and he just hadn't filed it, he was filing it that day,
Okay,
so he was up here
Yeah.
reviewing the file.
okay. If you can find it for me.
Yeah, they did. I just appealed it. Anyways, next. Next.
Wonderful. Who would like to place the agreement on the record?
I can do that, Your Honor.
Please, Ms. Billmeyer.
All right,
She
Your
likes
Honor,
it
these
on the
parties separated right around July, but they have been discussing divorce for a very long time, and they actually came up with their agreement, and we have just tweaked it. So we had the honor of recognizing that these two got along quite well. They have agreed that they will share joint physical and joint legal custody of their two minor children. That would be Addison Marie Homan, born February 6, 2010, and Brianna Homan, born August 24th, 2012. And we have set forth in writing a consent judgment entry that Tony has in his possession as well, and the parties have tweaked that along the way. They further agreed that their parenting time for the two minor children is going to be on an equal basis. They have agreed to a 2-2-3 alternating weekend plan. Of course, I have a hair. They are also, I'm going to attach the court's their holiday schedule, and they have agreed to follow that. With regard to extracurricular activities, the parties have agreed to share those equally, and we actually set out some specifics in the entry itself because one of their daughters is in a competitive dance, which is very expensive, but these parties have agreed to share those expenses. With regard to the income tax exemption or credits, Mother is going to claim Brianna in every tax year, and father is going to claim Addison in every tax year. Once Addison is no longer able to be claimed, father will claim Brianna in odd numbered years, and mother shall claim Brianna in even numbered years. Mother is going to continue, as she has been, providing health insurance through her employment so long as it continues at a reasonable cost. We've set forth the reasonable cost to 6% of her gross income. With regard to child support, father is on Social Security disability and also receives a derivative benefit for the two daughters. When we put that into the Michigan support guidelines, we came out with an outcome of one child, father would pay to mother for one child, a total of $114. That's a base support of $43. Healthcare premium adjustment of $51, ordinary medical at $20. For two children, the base support came to $66 with the healthcare premium adjustment at $103, ordinary medical at $41 for a total of $210 for two children. And I will go ahead and attach the uniform support order to the judgment entry. With regard.
So his child support is $1 or $100 or something, $140, but she's in competitive dance? Who the fuck's paying for that? I'm so worried about these bookcases falling on these gentlemen. I feel like there's a lawsuit waiting to happen there.
And then we do have the domicile, the 100-mile rule, and the Hague Convention rule in our judgment entry. With regard to spousal support, the parties have agreed.
Hold on, did she just reference the Hague Convention? We don't often hear that in Michigan law. Obviously, the Hague Convention, which governs like world dynamics in terms of parenting and custody. It's like the parental kidnapping sort of world doctrine, I think. I assume that it references something like not moving within or out of 100-mile radius from. Although, I don't know that we have that here. And I think perhaps just the size of Canada itself prevents a rule like that from being implemented logistically. Like, I don't know.
Agreed that neither party shall pay the other support and that the same is forever barred. With regard to the marital home, the parties had owned a home at 6970 Pheasant View in Bedford. They listed that for sale. That home has sold, and they divided the proceeds equally among themselves. Parties also own vehicles. Husband has a 2022 Dodge Ram that he leases, and he will be responsible for that going forward. With regard to wife's vehicle, she has a 2018 Chrysler Pacifica. Did you get a new car?
No.
Okay. Chrysler Pacifica free and clear. She's awarded that free and clear of any interest of husband. And did you guys take care of the title yet?
Yes, we have.
Okay. So they were both on the title. They've already taken care of transferring the title to wife. So that's good. Along with their separation in July, they have divided all of their personal property, furniture, jewelry, tools, household goods to their mutual satisfaction. Each is going to retain what's in their possession now. With regard to the bank accounts, the parties had a joint bank account at Key Bank. They have agreed to close that and disperse the proceeds. With regard to Addison has a bank account, and that account is preserved for her. With regard to their pension and retirement benefits, wife participates in a Fidelity 401k through her employment. Husband has a Fidelity 401k through his previous employment. And he also participates in an Edward Jones IRA. Tony and I agreed while we were negotiating this case that we were going to use a valuation date of July 31st of 2024. So we valued everything. We offset some assets, and we have agreed to equalize that through the retirement fund of husband. So wife is going to be awarded $78,155.50 from husband's 401k through Fidelity, pursuant to a qualified domestic relations order that will be prepared by either Kudrow Group or Ann Pastrana. I have not used her yet, but I would like to explore that. They have agreed to be equally responsible for the cost for that preparation of that Kudrow. Wife is also awarded her 100% of her Fidelity 401k free and clear. Husband is awarded his IRA through Edward Jones free and clear. And they do have some type of joint tenant with a right of survivorship in a portfolio through Edward Jones that's worth 6 cents. They agreed to close or terminate that fund. Going forward, each party is responsible for their own health insurance. With regard to marital debt, each party is going to be responsible for their own credit cards and debt in their sole names. I don't believe there was any joint debt that we had to divide, correct? Okay. Each party is going to be responsible for their attorney fees. And Your Honor, I believe that is the sum and substance of the parties' agreement.
Thank you, Ms. Billmeyer. Mr. Bruskel, did Ms. Billmeyer accurately state your client's agreement?
Just a few small additions. There's a couple 529 plans. It looks like husband's the account holder, and he'll continue to maintain those accounts for the benefit of the children. The language that we agree to says that wife's entitled to obtain statements from husband pertaining to the funds upon request. And in the event the funds cannot be used for purposes of 529 plan for either or both children, the proceeds of the funds shall be given to the children. We agree to that language. And I think it's silent to it, but it is implied, Amber, but the division of the retirement accounts as of July 31st should be with gains and losses as of that date for the benefit of wife. Even though we didn't say it, we'll probably get a note from one of the companies asking us if that was our intention. So we would agree that is, of course, going to happen. She'll be entitled to gains and losses as of July 31st. Otherwise, everything else was perfect, Judge.
Thank you. Ms. Billmeyer, those modifications acceptable?
Yes, Your Honor.
Very well. Before the parties are sworn, the court would note that the statutory 6-month waiting period expires in December. And of course, this court will waive that if the parties both requested the court do so and they believe it would be best interest of their child to finalize things sooner than later. So perhaps we can address that during the voir dire. Mr. and Mrs. Holman, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Ms. Billmeyer, you can begin with Ms. Holman, please.
Sure. Danielle, can you state your full name for the record?
Danielle Ann Holman.
Do you currently reside at 1019 Fire Creek Court in Temperance, Michigan?
I do.
And you separated from your husband back in June of 2024, correct?
Correct.
But you had been contemplating divorce for quite a while.
Yes.
And are you asking that the court waive the 6-month period for you to be divorced?
Yes, I am.
Okay. With regard to the consent judgment entry of divorce, have you read this document?
I have.
Do you understand the document?
I do.
Do you have any questions or concerns about it?
I do not.
During the course of our negotiations, did you disclose all of your assets and liabilities with regard to your marriage, your
Yes,
marital estate?
Yes,
Okay,
I have.
all right. When we filed your complaint for divorce, we alleged that you were a bona fide resident of the state of Michigan for at least 180 days and in the county of Monroe for at least 10 days. Was that true?
That is true.
And you still live in Monroe, correct?
I do.
All right. We also alleged that you were married on October 7th of 2006. Was that true?
That is true.
And that there were 2 children born as issue of your marriage, correct?
That is correct.
And are their names Addison Marie Homan and Brianna Kate Homan?
Yes,
Was Addison born on February 6, 2010?
she was.
Was Brianna born on August 24th, 2012?
She was.
And I'm sorry to ask you this, but are you currently pregnant?
I am not pregnant.
When we filed your complaint for divorce, we alleged that there had been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved. Was that true?
That is true.
And it remains true today.
It does.
And are you asking that the court approve the agreement we just read into the record and as written with some ads that Tony, we discussed during this hearing? Are you asking that the court
Who the fuck's Tony? I thought his name was Norman. We talked about this. Normie. Norman? Who's Tony? Is Tony her ex-husband? Trish, thanks for stopping by. We will be thinking of you and sending good vibes. Come by anytime. Can anybody guess who that was on the phone? It is so simple in my life. Some days. Anyways, let's go.
finalize your divorce?
Yes, I am.
Thank you. That's all I have, Your Honor.
Thank you,
I
Ms.
think
Billmeyer. Mr. Briscoe, do you have any questions for Ms. Holman?
No, Your Honor.
Questions for Mr. Holman, please.
Thank you, Judge. Rob, you've heard the agreement we're placed on the record here this morning, right?
Yes.
Is this the agreement that you and your wife have freely negotiated with one another and that Amber and I have tried to reduce to writing for you?
Yes.
Okay, and all the provisions pertaining to custody and parenting time in the children, do you believe they're in the best interest of the children?
Yes.
And all the provisions regarding the property settlement, have you heard them? And do you believe that they're accurate and they reflect your actual marital estate being divided fairly?
Yes, I do.
Okay, you understand in Michigan, we have a thing called spousal support. It can be paid to men as well as women, and you're voluntarily waiving that right, correct?
Yes, correct.
Okay, you're not asking for any spousal support now, and you know you'll never be able to come back and get it.
Correct.
All right. Have you truthfully and accurately and honestly disclosed all of your assets and liabilities that were that you came to in the marriage during the course of our negotiations, both with the attorneys and with your wife?
I have.
And when you filled out your domestic relations verified financial information form, everything on there was accurate and truthful, and it was fully disclosed.
Correct.
Okay. There was, with regard to the 180-day period, you guys have been separated at this point in time. Do you believe it would be in the best interest of the children to allow the court to enter your judgment of divorce faster than the 180-day period to just continue to maintain the continuity and the lifestyles that you guys are already engaged in and moving on and to foster the new environments that you have in your current homes?
I do.
Okay, thank you. Judge, I have nothing further.
I'm sorry, Mr. Briscoe, Mr. Holman is also asking the court to waive the statutory balance of the waiting period.
Yeah, yes, Rob,
Yes.
are you asking the court to waive that period?
Yes, I do.
All right, thank you. Ms. Billmeyer, do you have any questions for Mr. Holman?
I do not. Thank you, Your Honor.
And Ms. Billmeyer, you'll prepare the judgment, is that correct?
Yes, I have.
Thank you. Further, the court would like to thank and acknowledge Ms. Billmeyer and Mr. Briscoe for helping facilitate the resolution of this matter, but the court would applaud the two of you, Ms. Holman, for reaching your own agreement. It's wonderful you can co-parent your children. They will thrive because you're on the same page for their benefit. So the court sincerely applaud you for that. At the request of both of you, the court will in fact waive the balance of the waiting period and enter the judgment upon presentment. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Billmeyer, Mr. Russell. Have a great rest of the day. You can zoom out.
Thank you, Judge.
You're welcome.
Thank you.
Thanks, Amber.
Thank you, Tommy. Good to see you.
You
too.
What the fuck was the Norman talk?
Yes, I didn't realize. Tony.
Ma'am, you're not muted. Okay. Judge, what's your little side comment now?
This doesn't matter. It's not really. Yeah, I guess we could. Yeah, we probably should because it is on document grab. I don't see it.
I don't know what you're talking about, Judge. But I do know that brings us to the end. Oh, what's she eating? I'm hungry too, girl.
Okay.
Oh, Judge, go away. Judge, go away.
Troy Licata versus Michelle Licata.
For the record, this matter is before the court post-judgment issue to review the spousal support of urges as well as status of a bankruptcy action in which the plaintiff is involved. Both parties represented by the legal counsel, and they've agreed to adjourn this matter to October 22nd, 11 a.m. Andrew, I forgot we arraigned that Michael Carter last week, and I forgot we set that for 12:15 this morning.
Yeah.
So,
I have it on our list.
yeah,
You twisted my rubber arm.
Yeah.
Fine, one more.
I forget that you mentioned.
One more, then we're done.
Good morning. We're just waiting for Russell Smith and his client.
Okay.
Sir, are you in a barn? Are those stacks of wood, pool noodles, etc. above you? Is this possibly the craziest angle?
It's caramel. It's caramel. Oh, it's caramel. Yeah, but the creamer smells really good. Yeah.
I'm not sure yet, Vicky. It really depends on how the rest of my day goes. A garage? That's a garage? We don't have garages here. You park your car on the street or in your driveway. If you have a garage, you rent it out for $1,200.
Anna Maria Island got demolished, even though the storm was 40 miles offshore.
Oh, yeah.
The whole island, yeah. Every structure that had a ground floor level had water in it. They look at some aerial photos. It looked like snow on the ground. It was all sand. The sand, yeah, from the Gulf pushed all the way across the island. It's only, of course, the island's only half mile wide, but.
Is your place still okay?
Well, it's up on, yeah, there's under parking, so I think it's probably okay. But yeah, it's the worst damage island has ever experienced. Yeah, of course, it's a storm surge.
Is your restaurant still there?
And it's major damage to the sandbar.
Oh, no.
No, he suffered in the storm.
Oh.
About months before they reopened. We blew out windows. So we go to Florida every year. And Charles sold his free restaurants.
You told me
Yeah, it's a good timing for him. Everyone's saying a good time for him. Okay.
Okay, I guess everybody's here.
Calling the matter of Derek McMurray, Catherine McMurray.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court. This pretrial conference is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff, Derek McMurray. Mr. McMurray is present. In addition, Attorney Russell Smith is present representing the defendant, Catherine McMurray, and Mr. McMurray is present with Mr. Smith. Good morning, everyone.
Good morning.
Morning, Judge.
The court has been informed, Mr. Walker, the parties have reached their own agreement. Is that correct, Ms. Nemec?
It is.
Wonderful.
Wonderful.
Who would like to place the
Monday.
agreement on the record?
I can do that, Your Honor.
All right, thank you, Ms. Nemec. Please.
So the parties have 3 remaining minor children. They agree that they will share joint legal and physical custody of those 3 children. Parenting time will be equal and reasonable and liberal as they agree. Each party is going to have the right of first refusal if the other party is not available for any parenting time. Holidays will be exercised as agreed by the parties, or if they cannot agree, pursuant to the Monroe County Front of the Court holiday schedule. Child support is reserved. Ms. McMurrin is going to continue to provide medical insurance for the benefit of the minor children, and any uninsured medical expenses will be split equally by the parties. With regard to tax exemptions for 2024, Ms. McMurrin is going to be entitled to take all 3 of them. And then commencing for the tax filing for 2025, Mr. McMurrin will be entitled to take 2 tax exemptions and Ms. McMurrin 1 in odd years, and Ms. McMurrin would take 2 and Mr. McMurrin 1 in even years. And they would continue to rotate that way going forward until they can each take 1. And then when there's only 1 child remaining, Mr. McMurrin would take that exemption in odd years. Ms. McMurrin would take that exemption in even years. Neither party is awarded spousal support, and the same is forever barred. With regard to the marital home, Ms. McMurrin is going to be entitled to retain that home. She will refinance the mortgage on that home within 120 days from today's date. And upon refinance, will pay Mr. McMurrin $40,000, which again shall occur within 120 days from today. The parties have 2 vehicles. Mr. McMurrin will be entitled to retain the 2010 Ford F-150. Which is currently financed in both parties' names. So he will refinance that vehicle within 120 days of.
I'm sorry. The 2010? You're refinancing the 2010? A 14 or 15-year-old car? Who's financing that? What are you talking about? How is it not paid off? How long are these loans? I've worked in car sales before, and we used to have 0% financing on 5-year loans. So, of course, that's a good thing. And, yeah, he might have Tourette's. But even a used car, like, you don't want to finance that.
Today's date, Ms. McMurrin is entitled to retain the 2009 Ford F-150, and Mr. McMurrin will sign that title over to Ms. McMurrin right away. Personal property is going to be divided as the parties agree, or if they cannot agree, they will agree to binding arbitration with Mr. Godfrey. They will need to request binding arbitration within 180 days of today's date. And if binding arbitration is not requested by either party by that date, they will retain whatever property is in their possession at that time. With regard to bank accounts, each party is entitled to keep the bank account in their own name. They do have 1 joint account at PNC Bank. Ms. McMurrin is entitled to keep that, and Mr. McMurrin's name will be removed from that account. With regard to debts, each party is going to keep the debt in their own name. Each party has life insurance, and they are going to be entitled to keep those policies. And finally, with regard to retirement accounts, each party is going to keep the retirement account in their own name. And I am informed Ms. McMurrin is not looking for restoration of a former name. And I believe that's the entirety of the agreement.
Thank you, Ms. Nemec. Mr. Smith, did Ms. Nemec accurately state your client's agreement?
Absolutely, Judge. Did a fine job. I have no corrections, additions, or deletions to make. That is the agreement of the parties.
Thank you. Mr. and Mrs. McGurran, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. The court would note the proofs were taken on January 19th. So perhaps, Ms. Nimick, you can just proceed with confirming with your client the agreement that's been placed upon the record. Mr. Smith can simply update the proofs by confirming with Mr. McMurray she's not now pregnant. But with that, Ms. Nimick, please.
Yes, thank you, Your Honor. Derek, can you state your full name for the record?
It is Derek Richard McMurrin.
And did you hear the agreement as I placed it on the record?
Yes, I did.
Did you understand it?
Yes, I did.
Do you have any questions about it?
No, I do not.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anyone forcing you or coercing you to enter into this agreement?
No.
Okay. Do you think that the agreement that you and Catherine have come to with regard to custody and parenting time is in the best interest of the minor children?
Most definitely.
Okay. Do you believe that the property division you've agreed to is fair and equitable?
Yeah.
Do you understand that by placing this agreement on the record today, it makes it binding on you?
I do.
And you know that means that you can't come back tomorrow or 10 years from now and ask the judge to make any change to the property distribution aspects of this agreement.
I do.
Okay. And you know that means you can't ever come back and ask for spousal support.
Correct.
Okay. And you understand that you could have taken this matter to trial and the outcome could have been different. It could have been the same, better, or worse.
I do.
And rather than take it to trial, you're asking the court to adopt the agreement that we put on the record and make it an order of the court.
I do. Yeah.
Have you disclosed all of your assets and liabilities to Catherine?
Yes.
Are you satisfied with my representation?
Yes.
I have nothing further, Your Honor.
Thank you, Ms. Nimick. Mr. Smith, do you have any questions for Mr. McMurrin?
I do not, Judge.
Questions for Mr. McMurrin, please?
Yes, thank you, Your Honor. Mrs. McMurrin, are you pregnant at the present time to your knowledge?
No.
Now, you've heard the agreement that's placed on the record, have you not?
Yep.
And this is something basically that you and your husband negotiated with the assistance of attorneys, correct?
Yes.
Do you believe that the judgment is fair regarding the minor children, the custody arrangement?
Yes.
Do you believe that the property settlement that we struck is fair?
Yes.
And you understand, do you not, that you're awarding your soon-to-be ex-husband his 401k in its entirety,
Yes.
and that you're not getting any portion of that?
Nope.
And as a matter of fact, you don't have a retirement account, correct?
Correct.
But never.
Well, there you have it, Mike. She's bending the mold. She gave him his whole retirement. She doesn't have her own. She's not fucking him. I know. She looks like a bitch, but it turns out I don't think she is in this case.
Unless this is something that you want to do.
Yes.
Okay. And
I have a small retirement, but it just got started. $50 maybe. So
50? Okay.
yeah,
So
just nothing that we can, yeah.
That goes
I don't
to
wanna
you.
lie.
That goes to you, and his retirement
Yeah.
account, which is much more, goes
Yeah.
to him in its entirety.
Yes.
And you're okay with it?
Yes.
You understand there's no provision for spousal support in the judgment, meaning you can't come back in and ask for that. Used to be known as alimony.
Yeah.
And you're not going to get that.
Nope.
And that's okay with you?
Yeah.
Did you understand all the other terms and conditions of the judgment?
Yep.
And regarding the house, you understand that the house is awarded to you, but you have to refinance it within 120 days,
Yes.
correct?
Mm-hmm.
And you also understand that the truck that your husband is receiving will be refinanced in the same period of time.
Right.
You also understand, do you not, that we could have taken this to trial before Judge Bronlick,
Mm-hmm.
and he could have come up with something similar or something quite different.
Mm-hmm. Yes.
Now, by putting this on the record, it is binding on both of you.
Yep.
Neither one of you tomorrow can come in and tell their attorney, hey, I don't want to do this. It's etched in stone.
Yep.
And this is acceptable to you?
Yes.
Now, I've represented you throughout this proceeding, have I not?
Yes, you have.
Have you been satisfied with my representation?
Very much.
Thank you very much, Ms. McMurrin. Your Honor, I have no further questions for her.
Thank you, Mr. Smith. Ms. Nemick, do you have any questions for Ms. McMurrin?
Just one. Catherine, have you disclosed all of your assets and liabilities to Mr. McMurrin?
Yep.
I have nothing further. Thank you, Your Honor.
Ms. Nemick, you have prepared the judgment, is that correct?
I will.
Thank you. Oh, the court would like to thank and acknowledge Mr. Walker, as well as, of course, Mr. Smith and Ms. Nemick for helping facilitate amicable resolution. And the court would applaud the two of you, Mr. McMurrin, for reaching your own agreement. What if you can co-parent your children? They will do well because you're on the same page for their benefit.
Thank you.
Based, however, on the testimony that's been presented this morning, as well as previously, as well as complaint filed in this case, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment approved by the parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Nemick and Mr. Smith. And now we'll conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you, Your Honor. Have a good day.
Welcome.
Thank you, Ms. Nemick. Mr. Walker.
I second and third that motion. Have a wonderful day. If I go live later really depends on how my workout and rest of my day goes. But I'll let y'all know. I'll either post a community post or I will schedule a show. I hope that you had a good time today. I'm sorry we weren't in the kitchen again. It's just, although you think it might be pleasant, and you know, I have actually done a few, we'll call them live shows. Like Donna watched me do a few live shows, but it's actually not as exciting, and it's quite intrusive. All the lights and computers and cameras and keyboards and all that kind of stuff. So the lemon blueberry cake turned out incredible, Mike. This week we are focusing on healthier treats, healthier snacks that we're gonna make. So tomorrow in the air fryer, we're gonna be making roasted chickpeas. Yeah, that's what it is, roasted chickpeas. If you want to join me along, go grab a can of chickpeas at the grocery store and get your air fryer ready, and we will do it together tomorrow. You don't even need any oil on these, which is exciting. If you have dry chickpeas, I think you can soak them, and they will be perfect for tomorrow. We're also gonna do a salad day this week where we make a salad dressing. It's gonna be fun. So we have lots on the agenda coming up, but I appreciate you being here today. It's been fabulous. Thanks for waking up with me, starting my day, having my coffee. Remember that I love you. I'm proud of you. Oh, and that Credence and Mikey are back from their vacation. So we need to show up in full force at We Gotta Chase and welcome the boys back. The boys are back in town. It's funny how YouTube feels like a little town, you know? Oh, also I saw Loud, are you here? Comment later if you see this. On one of my gambling videos channels that I watch, I saw a comment from Loud that was quite funny. So, and yeah, let's make sure we are all there together. It is at, what time? 1:05 Pacific, which is 4:05 East. Yeah, remember that. Remember that I love you. I'm proud of you. And I'll see you in the next video. Bye.
Ways down and ready to ride.